Big developments are unfolding in the ongoing fight to defend our Second Amendment liberties. The United States Supreme Court just handed down a unanimous ruling, yes, all 9 justices in agreement that's now being used as a key weapon against state-level, so-called assault weapon bans. Although the case itself wasn't centered on rifles, the wording used in the court's opinion could become a legal game-changer in how America views gun ownership moving forward. In this breakdown, we'll cover how this verdict ties directly into California's rifle restriction case, why it's making waves, and what it might mean for the future of firearm freedom in this country. The front lines, California's semi-auto rifle restrictions. For over a decade, states like California have been pushing aggressive bans on certain types of semi-automatic rifles, not because of how these firearms operate, but based purely on how they look. If your rifle features a pistol-style grip, a detachable muzzle device, or a collapsible buttstock, it's labeled a prohibited assault weapon. These regulations have never been about stopping criminals. They've always targeted responsible gun owners. At the heart of this battle is one core question: do these cosmetic bans violate the constitutional right to keep and bear arms? Recent court rulings and centuries of American legal tradition suggest that they do, and a brand new decision from the nation's highest court might be the final push that gun rights advocates have been waiting for. The core fight, Miller versus Bonta. Let's zero in on the California lawsuit that's currently at the center of this constitutional standoff, Miller versus Bonta. This case challenges the Golden State's sweeping ban on a broad class of rifles, based not on performance, but on superficial details like a threaded barrel, adjustable stock, or a vertical front grip. In California, if a law-abiding citizen owns a modern semi-automatic rifle with any of those features, it's automatically categorized as an illegal assault weapon. Federal District Judge Roger Benitez originally heard the case and ruled strongly in favor of gun owners. He concluded that California's restrictions clearly violate the Second Amendment, citing the Supreme Court's text, history, and tradition test established in District of Columbia versus Heller and reinforced in New York State Rifle and Pistol Association versus Bruin. Under that framework, commonly owned firearms used for lawful purposes are off-limits to blanket bans. But California didn't take that loss lightly. The state appealed, and the case stalled at the Ninth Circuit Court of Appeals, where it was delayed behind another major lawsuit, Duncan versus Bonta, which took on the ban on what the state calls high-capacity magazines. Once Duncan moved forward and not in our favor, Miller finally started moving again. With oral arguments wrapped up and legal briefs filed, the Ninth Circuit now has a choice: align with the U.S. Supreme Court or continue resisting constitutional precedent. The unexpected bombshell, Smith and Wesson versus Mexico. Here's where things get really interesting. In a completely unrelated case, Smith and Wesson versus Mexico, the Supreme Court issued a 9-0 ruling that technically wasn't about gun rights at all. The main issue was whether American gun makers could be held responsible under foreign law for crimes committed with their firearms in another country. The court's answer? A firm no. But buried in the opinion was language that could have massive implications here at home. The justices described firearms like the AR-15 as being widely legal and commonly owned by law-abiding citizens for lawful purposes. That may seem like a minor detail, but under Heller and Bruin, that kind of language is incredibly important. If a firearm is in common use for legal purposes, it is protected under the Second Amendment period. This wasn't a razor-thin 5-4 decision. This was all 9 justices, across the ideological spectrum, on the same page. That kind of legal clarity carries serious weight. Even though the case wasn't technically about the Second Amendment, The wording echoes and reinforces previous rulings, and now those very words are being quoted in briefs filed in Miller versus Bonta. Gun rights advocates are using this new decision to argue that modern rifles, like the AR-15, are not only constitutionally protected, they're protected by the very same court that unanimously made that point clear. Their brief makes it clear. This language from the Supreme Court isn't just an opinion, it's binding precedent. Whether the lower courts are willing to recognize that is another matter. But what's crystal clear is that this Supreme Court ruling has handed Second Amendment supporters a potent new argument, and it couldn't have landed at a more critical moment. The common use wedge, driving the legal fight. So how are Second Amendment attorneys using the Supreme Court's own words to go after California's so-called assault weapon law? It boils down to one key concept that the High Court has repeated for over a decade: common use. Since the District of Columbia versus Heller decision, the rule has been crystal clear: firearms that are widely owned by responsible citizens for lawful purposes, such as self-defense, cannot be banned. That rule was reinforced in Bruin, and now again, though indirectly, in the recent Smith and Wesson ruling. The legal team in Miller versus Bonta isn't dancing around technicalities. They're going straight for the jugular. Their claim? Rifles like the AR-15 are some of the most commonly used firearms in the United States, period. An under-established Supreme Court doctrine that makes California's ban unconstitutional, no asterisk, no exceptions. The state of California argues that AR-style rifles are dangerous and unusual. But that argument collapses when the Supreme Court has already described these rifles as commonly owned and widely legal. That distinction matters a lot, because only weapons that are both dangerous and unusual fall outside the protection of the Second Amendment. The AR-15, used by millions of gun owners across the country for home defense, recreational shooting, and competitive marksmanship, doesn't even come close to fitting that label. And here's the kicker: judges in lower courts generally don't like to flat out defy a 9-0 ruling from the nation's highest bench. Once something is considered settled law, it becomes much harder for them to find legal wiggle room. That's why this common use approach is so powerful. It doesn't ask judges to invent new interpretations, it just demands they follow what the Supreme Court has already laid out. In that way, Smith and Wesson has become more than just a manufacturer liability case. It's now a pry bar being used to crack open unconstitutional rifle bans nationwide. The Ninth Circuit's resistance. Now let's talk about the Ninth Circuit and the headwinds facing the Miller case there. The oral arguments made it painfully obvious not every judge on the panel is eager to follow Supreme Court precedent. Some appeared outright hostile toward it. During the January hearing, one judge inaccurately referred to the AR-15 as a machine gun, while another bizarrely called it an A-15, showing not only a misunderstanding of the platform, but also an alarming lack of technical knowledge for someone sitting in judgment of gun laws. That wasn't just ignorance, it was bias, plain and simple. Several on the panel downplayed how widespread these rifles are, focusing narrowly on ownership numbers inside California while ignoring that tens of millions of these rifles exist across the United States. One judge even suggested that the common use principle might not apply in states where fewer people own guns, completely missing the point of a federally protected constitutional right. That kind of logic would mean your Second Amendment rights change depending on your zip code, which is absurd and legally unsound. What's happening here isn't just disagreement, it's judicial defiance. Even with clear direction from Heller, Bruin, and now Smith and Wesson, some judges are trying to sidestep precedent. They're minimizing the Supreme Court's words by calling them non-binding or dismissing the relevance of nationwide statistics. Their playbook is simple: stall, confuse, and delay. Instead of issuing a decision in Miller, there's a real chance the Ninth Circuit might push the case aside, again possibly waiting for movement in Duncan versus Bonta, which challenges California's magazine ban. It's a strategic move, keep the whole issue in limbo, pretending as though the legal waters are still murky, but they're not. The Supreme Court has spoken, and every day a lower court refuses to listen is another day the rights of American citizens are withheld not by law, but by judicial stubbornness. A national shift in motion. This fight isn't limited to California. The arguments being made in Miller and the precedent set by Smith and Wesson are echoing nationwide. If AR-15 rifles are indeed in common use, then every similar ban in places like Illinois, New York, New Jersey, and others is standing on legal quicksand. These state-level laws often use the same script, redefine a widely owned rifle as an assault weapon, then claim the redefinition justifies the ban. But if courts stick to the Constitution as clarified by multiple Supreme Court rulings, those bans can't legally survive. What Smith and Wesson gave us is more than legal phrasing, it gave us legal momentum. Gun rights attorneys all across the country are pointing to the ruling, using its language like a hammer. These rifles aren't rare, they aren't military grade, and they aren't outside the scope of lawful ownership. They're mainstream, they're normal, and they're protected. But here's the reality. Not every circuit court is going to fall in line. Some will dig in, hoping conflicting rulings will slow things down. That's already happening, and it's called a circuit split. When federal appeals courts issue opposite decisions on the same constitutional issue, it often forces the Supreme Court to step in and resolve the conflict once and for all. We're approaching that point now, whether it's the case from California or one out of Illinois or New York. Eventually, the Supreme Court will be pulled back into the center of the storm. And when that happens, the foundation laid by Heller, Bruin, and now Smith and Wesson will be impossible to ignore. The coming reckoning. This isn't just legal back and forth, it's a full-scale constitutional moment. A unanimous Supreme Court ruling has reinforced what many of us already knew. Rifles like the AR-15 are protected by the Second Amendment. That fact is now reverberating through courts across the nation. Laws once seen as politically untouchable are now facing hard legal scrutiny. And while some lower courts are doing everything they can to delay, the tide is turning. The Supreme Court's words in Smith and Wesson weren't just a footnote, they were a warning to lower courts that it's time to get in line with the Constitution. The only question that remains is this: will these courts follow that guidance? Or will the justices have to step in once again to remind the judiciary what the Bill of Rights actually means?